it's just yeah. Thank you.
All right, now we're on.
I don't know why I couldn't get it to record. But hi, everyone. I'm Diana Dunham-Nelson. I've gathered you all here today for a very, very important conversation. I know most of you are here to learn a little bit more about estate planning for yourself, but I'm here to introduce my good partner, Ray, my good friend, Ray. And the reason why it's very important for us to think about estate planning, not only for ourselves, but for our families, for our businesses, is it impacts us all in different ways. And for me, it was a little bit more dramatic. I was adopted at 3 days old. And so I was adopted by older parents, actually, my grandparents' best friends. And thank God for them. However, they did pass away when I was pretty young. My adopted mom passed away when I was 6. And by the time I was 17, my adopted dad had passed away, though he remarried to a younger woman a couple years prior to that. And she was abusive to us. She ended up being abusive to him as he became weaker and sick. And so people are just waiting to prey on assets, and that's exactly what she did. So eventually I was ward of the state, and she got to take everything when my father passed away. So our
Mama, there's Mama at the beach.
and it's so important to not only think about your assets and who you're going to pass them to and make sure it's properly structured, but also think about the children that you're leaving behind and what is the plan for them. I think that's one of the more one of the topics that I definitely want to highlight and make sure that we talk about, because a lot of us have children, a lot of us have families that we need to leave our assets to so that they can continue on with the plan that we have built for them. And so I feel like there's no better person or group to talk to us than Ray and Barry. And the reason why is because Ray has co-founded this amazing company that we've partnered with, which is called Trustee. And it's an online estate planning platform that combines smart digital tools with real human guidance to make creating wills, trust, and power of attorneys easy and affordable. Trustee Friends approach makes estate planning accessible, trustworthy, and simple for agents and their clients. And I'm a true testament to that. Had he come along or someone come along, an agent come along and talk to my parents, I'm 100% sure my life would have turned out a lot easier. So today, additionally, Ray has also been in the insurance industry for a very long time, and that's kind of how we met, because I'm in the insurance space. He also has owned 2 businesses in computer technology and worked international sales, mainly in Europe, and also was in the entertainment industry. So he's going to have to tell us a little bit about that and his global world tour with that. That's pretty exciting. And Ray also is originally from Los Angeles, and currently he resides in Vancouver, Washington. So I can imagine a lot of rainy and chilly days for you.
Yeah.
I haven't been there yet, but I'm so blessed to have met him and come across his company. Just really trying to bring more awareness to my clients, my family, and my friends about the importance of estate planning. And I have an amazing partner in Trustee Friend, and I wanted to introduce them all to you today. Right?
Awesome. So Diana, thank you for the rousing welcome. Really appreciate that. So just a little bit on touching on what you said. I used to be a DJ. I used to be an international DJ. So I used to travel around the world playing music. I got as far as Morocco and North Africa, playing festivals in front of thousands of people. I got a little bit older, so I decided to hang up or retire from the music industry after about 15 years. Fun fact about me, though, that I didn't mention to Diana when I sent her my bios, I used to be a minister, right? In my 20s. So I was an ordained minister for about 6 years. And people ask, how'd you go from minister to a rave DJ? I'm like, it wasn't easy, but I made it happen, right? So, but anyways, thank you so much. We hope to share a lot of really good information with you this evening. I do want to introduce, I did briefly, but I want to introduce a very good friend of mine. He's also works in our organization. He is an attorney extraordinaire. He is a law professor for 25 years. He's been practicing law that entire time. 15 years of that, he has been practicing primarily estate planning. He's an expert on special need planning. We're going to touch a little bit on that tonight. So I want to introduce from Chicago, Illinois, Mr. Barry Kozak. All right. So Barry will be here to answer questions, and I think this is a great time for folks that maybe had some, need a little guidance, maybe needed, I'm not going to say advice, but a little bit of guidance. This is your time to talk to an estate planning attorney. He's going to be right here, so start thinking about it. Maybe put some of your questions in the chat. But I'm going to go ahead and share my screen with you. We prepared a little a slideshow that's going to highlight some of the importances of getting your estate plan definitely sooner than later. Trustee Friend is the name of our organization. And the reason why we decided to call it Trustee Friend is, sometimes bringing or entering into this realm of estate planning, whether you're a client or you're an agent, can be a little bit intimidating, right? There's a lot of legal language that people don't normally come across every single day. It may be the first time that somebody's talking to a legal professional, an attorney like Barry or a paralegal. These plans can be anywhere from 60 to 125 pages long. And so we really wanted to make the process much easier for people to come work with us. We have a very friendly staff, very friendly approach. We have very open lines of communication. Right. We really wanted you to feel supported because this is a very important topic and something that a lot of people are waiting way too long to get started. Like Diana, I came from, a not so pleasant background, even though I've been able to accomplish some things as an adult. I didn't come from a family of entrepreneurs or go-getters. Both my parents were involved with gang activity when I was a child, and both my parents passed away when I was still a child. And I tell people the only thing my parents left behind were five broke little boys. Okay, my four brothers and myself. They didn't have any life insurance, which is very important too. They didn't have an estate plan. They didn't have a savings. I'm not even sure they had jobs when they passed away, so we had to go live with a single grandparent who was retired. You can imagine how difficult that made life growing up, not having a lot of resources. And so as I got older, I decided that I was going to devote, at least part of my career and my life to helping other people understand how important proper protection is, right? Estate planning is part of it. Life insurance is another. And you can talk about Diana, talk to her about your life insurance needs after this is completed. But I want to go ahead and get started and delve into what exactly is an estate plan, like why do we all need it, what is it? Okay, number one, it's a legal rule book outlining exactly how your assets should be managed, protected, and distributed, giving clear instructions to your decision makers and ensuring your wishes are carried out without confusion. I always say this is planning with intent. Okay, you really need to have a game plan for the times that maybe we're not here. Perhaps we're the sole breadwinner for our family. We want to make sure that we have everything protected legally, it's organized and distributed the way we want to. It also provides protection, right? You said protection from what? From the delays, costs, and public nature of probate. We'll talk a little bit more about probate in a second. By ensuring your assets transfer smoothly and privately, which is important according to your instructions, right? We're going to have Barry touch on a little bit on how important that privacy here is in the next page. And then lastly, I think probably the most important thing is that peace of mind that it brings. Um, Roughly 75 to 85% of Americans are living without an estate plan right now. Okay. 70% of people pass away without ever getting their estate plan completed. And I couldn't imagine being on maybe in a hospital bed and I'm there and I'm terminal and I'm thinking to myself, I didn't get my family protected. I didn't get my estate protected. That's not the type of peace of mind. That's a lack of peace of mind, actually. And that's not how I want to go. And that's definitely not how I want to leave my family in a situation. So knowing your wishes are documented, your loved ones are protected, and that your plan will guide them clearly during life's most challenging moments, I think is really something that we should all focus on and how we want to set our families up for success again, when and if we're no longer here. So I want to talk about a few scenarios and why estate planning is so important. And then I'm going to ask Barry to help me out with a couple of these. Number one, you see the couple there in the far left-hand corner. Having a properly written estate plan can really help prevent conflict within a family. Barry has seen it. I've seen it. I can't tell you how many times we've sat with a person or a family where there's no estate planning, and it just creates such a hostile environment. People tend to get greedy, right? People think that they're entitled to things that maybe they're not. It's just a very unpleasant experience. We have seen cases where people try to prosecute the other person. It destroys relationships, right? Ongoing. And, even sometimes with an estate plan, there's conflicts, but definitely having that plan in place is going to reduce, that stress that comes when it comes to dividing out your assets. We don't want to have, this type of situation going on with our family when we're no longer here. Second is it avoids probate. Just to give you an idea of how serious probate can be, right? Right now, every year, the probate industry is about $2 billion a year. Okay. And half of that money is going to attorneys. Okay. And I always say that actually should be going to who? Should be going to the family rather than to an attorney. And it can if we do what? If we prepare sooner than later. And here's the thing, it's not just regular folks like you and I that sometimes fail to plan ahead. Some very wealthy, well-to-do people have failed to plan ahead, and there are consequences to that. Number one, it takes a very long time to get through the probate court process. Many of the courts are backed up 2 years or longer. There's a very famous case that I'm sure most of you have heard of, very famous musician, icon. He went by the name of Prince, right? Most of us know who Prince is, Purple Rain. He passed away without an estate plan, and it took 6 years to take his estate to the probate court process. Okay. And think about this. He was surrounded by very smart, influential people, people managing his business, and not one person, it's hard for me to believe, suggested that maybe he get a trust and will, right? So if people weren't watching out for him, imagine us, okay? Now, most of us don't have the wealth that Prince had. Okay. It was also at a cost of $3 million to take his estate to the probate court process, which is a lot of money. But even with just regular folks like you and I, no matter where you're at, social, economically, the process can still be very expensive for our loved ones. I'm just going to give you a very quick way to try to figure out potentially what probate court costs could be. So, Diana, let's just say that you had a colleague, a friend, relative that passed away, and they had a home, and that home was valued at $500,000, and they died without a trust and will. Typically, the cost that it would take to take that home to the probate court process is about 10% of the value of the home. So 10% of 500,000 is what? $50,000. Okay. And these are true to life costs. People live in very expensive parts of the country, or they just have a bigger home or bigger state, let's say $1 million. 10% of a million is what? $100,000. And that's typically the cost that it could take, right? To transfer that estate to the probate court process. Now, my question to mostly everybody here is how many of you have $50,000 to $100,000 lying around to pay attorneys, right? Like not many of us. And even if we have that, do we want it going into attorney? Do we want it going to our family? Okay. Another big issue is privacy. Okay. When we don't have an estate plan, okay, or if we have a will alone, and we're gonna touch on that in a little bit, there could be some privacy issues here. And I want to bring Barry in to talk about some of these privacy issues that can happen if an estate has to transfer through the probate court process.
Okay, thanks. So probate again, it's each state says if someone is a resident and they pass away, we need a wise judge in a probate courtroom to figure everything out, unless someone takes action and creates an estate plan. So probate is public. So if you have nothing to do on a Thursday afternoon or whatever, go to your local county courthouse, find out which room is the probate hearing, and go and sit in the back of the room and learn about a neighbor who died because they're public. But after the probate is over, the will, if there is any, the list of assets, the list of creditors, it gets published. That's why Ray can Google Prince or Aretha Franklin or Elvis Presley because their estate went through probate. Some of the stars who did trusts and tried to keep things private We don't know what happened. So it's and as I say, so the idea again, it's not like you did anything bad. The idea is the state says we need a judge to figure out everything unless there's legal documents that kind of spell everything out. And just kind of as an aside, the story with Prince is even worse because he was not married and he did not have children and he did not even do a will. So under our laws, which come from jolly old England, which only care about who's the blood relatives, his estate of $150 million, even though he was one of the most charitable people in the world, his estate was divided between his two siblings and two step siblings. And from the news accounts, he didn't even know these people during life. But that's who inherited. Luckily, one of the attorneys was able to carve some of it out to go to the charity. But the idea is that's what happens without planning. And Prince was a young, vital superstar who thought he was going to live many more years and was always, oh, I'll do it later, I'll do it later. And that's part of the moral of the story, that he just didn't do it when his time came. So again, and just one other quick thing, I don't want to take it. Going back to the first one, to prevent conflict, surprisingly, it's not the children that fight, it's the children's spouses. So those of you who are parents and you're like, well, my kids get along wonderfully, and when we pass away, no one's going to fight over the grandfather clock or the chipped cookie jar or who gets what or whatever. It's the spouses that usually are the ones that cause the conflict. So just understand that, be prepared, to kind of tell that to one of your clients who's like, oh, this doesn't concern me. The conflicts come when the conflicts come. So
Thank you so much, Barry, for that information. If we look to the far right, uh, a well-written estate plan can also name trusted people to act on your behalf when you can no longer do so for yourself. I always tell people, and you can see the situation, this person looks like they're unconscious, potentially in a coma. And really, when we're in that type of situation, we need a voice when we're voiceless. We need somebody to be able to handle legal, financial, healthcare matters. Um, we can no longer do so ourselves. This is where a power of attorney comes in, and really helps list out who we want to take care of situations we cannot do so ourselves. And in my opinion, and many attorneys, anybody over the age of 18 should have at least a power of attorney, right? When you're 18 years of age in this country, you're considered a what? Right? An adult. And there's certain laws put in place to protect the privacy, at least from a healthcare and medical perspective. They're called HIPAA laws. Well, guess what? Those apply to our children as soon as they turn 18 too, regardless of whether they're living at home or not. So if something should happen, I've got a 14-year-old, I've got two adult children, but once my 14-year-old turns 18, guess what we're going to do as his mom and dad? We're going to get him a power of attorney. Because if he goes out with friends, gets into an accident, taken to the hospital, he's unconscious, right? And he does not have that power of attorney. We're not going to get a whole lot of information from that hospital as far as what's going on with him. They may call us and say he's been to an accident, he's there being cared for, and we won't typically be able to make any type of decisions for him, healthcare or otherwise. That means hospital staff, sometimes judges, right? We'll have to make these decisions for our loved ones. And I don't think any of us want to be in any kind of situation where we're not able to help our kids, whether they're young adults or not. Another thing, too, to take into consideration is most of us are going to get sick before we pass away. At least some of us are going to be in a situation of incapacity. And again, this is why it's so important to have that power of attorney as part of your estate planning for your kids. You can get it a la carte, right? Just a power attorney alone. But we want to make sure that everybody that we care about is protected in the best way possible. Down on the far left, for you business owners, we have a full array of business succession planning for you. We can actually help you establish your structure if you haven't already done so yourself, making sure you're structured correctly, be it an LLC, S Corps, but also succession planning, buy-sell agreements, exit strategies. I've sat with many business owners who've been operating for many years, and I'm like, okay, show me your plan if something should happen to you. I'm like, I don't have one. And it's like, what do you mean you don't have one? You need to have, some legal documentation letting people know what happens to the business when you're no longer here, right? Because that happens. Right there in the middle, I think this is probably one of the most important things. As I mentioned, I have a minor child still, and I'm sure there's some people here that do. I know for a fact that some people on this call do. And we want to make sure that in the event the worst happens, right? And it doesn't matter if you're a couple, single parent, or whatever, things happen in life. And that sometimes may put our children in jeopardy. And what I'm talking about is if we don't have a legal guardian named and something should happen to us as parents, okay? Typically, the first course of protection is going to come from the state. And what I mean by that is they're going to take those kids and put them in foster care, right, until they can find a suitable legal guardian. And again, I'm going to invite Barry to just kind of expand on this a little bit, but this is a real situation that people just don't think about until it happens and typically till it's too late. Barry, you want to chime in a little bit on this?
Sure, and there we deal with some clients that come from some cultures that, well, obviously, if I die, favorite uncle or favorite grandmother or someone's going to come in. That's not our set of rules in any of the states. The judge, so anyone who's a minor child, a judge must appoint a guardian. What we do is, as Ray said, who are the names of the people you trust? So the judge has a list of people to choose from. If favorite grandma, the top person on the list, if she could do it, okay, she's appointed. If not, we go down the list. Um, I told a story last week. I'll tell it again. True story. My sister-in-law, my brother's wife, one of six children. They all live in the same kind of area in New York, and they all have kids very close. When not my sister-in-law, but her brother, her sister, and her husband were in a common car crash. Didn't do their planning ahead of time, and the fighting was each one saying, "I'm the best aunt. She would have wanted me to be the guardian. No, I'm the best uncle." And the fighting between them and everything coming out, well, you're the one who kind of locked me in a closet when I was 8 years old. It was a horrible thing for the children. I don't know which one they wanted. So the idea is, in a lot of times, it's who do you want to go and who do you not want to be put in. But if you don't plan ahead, again, there could be fighting there. So the idea is we give a list to the judge, and the judge is going to go down the list. So it doesn't have to be a list of 20 names, but we always like at least two or three. Just kind of, it's so much better, even if it's a cousin that maybe it's better than foster care, probably. Just so.
Absolutely. Thank you for that, Barry. And then lastly, you know, again, planning with intent, making sure that everything you're working hard for, your legacy, your assets are passed on in the way that you want to, be it the next generation, maybe children, maybe grandchildren, maybe some legacy planning with great grandchildren, charities, churches, whatever it is that you want. It's your estate to be passed on the way that you want it to, right? And this is going to be that time for you to be able to plan that out. Now, let's talk about a plan, the basic documents inside Trustee's Friends Trust and Will plans. You've got that revocable living trust, which manages your assets and helps you avoid probate. Okay, revocable meaning it's flexible. You can make changes to it. You probably should make changes to it from time to time. Yeah, update it. It has that last will and testament, which distributes assets and names guardians. We're going to talk a little bit deeper about the difference between trust and will in a second. The power of attorney that I mentioned, which authorizes financial, medical, and legal decisions. And that would go to folks that you trust to make the right decisions for you, okay? And give some instructions as to the care that you want, maybe the care that you don't want, okay? And then, of course, the deed preparation in all our plans, we automatically prepare the deed to transfer the home into the trust to protect it from probate and mismanagement. And now I want to talk a little bit, as I mentioned, about the difference between a will and a trust. There is some misconceptions out there as to which one does what and what protects you from whatever. I want to make it very clear here that I think they're both good. Okay. And for people that say, well, I have a will, I'm like, great. That's better than not having anything. But to be able to give you an understanding of the full picture of protection, I want to go through these one by one. So a will, and most everybody's, if they hear about any type of estate planning, that's the first thing that they think of. Oh, a will, right? A will is a legal document that explains who should receive your property after you pass away and who you want to handle your estate and care for minor children. We kind of touched on that already, right? Those are all great things. It does not avoid probate. So I want to make that very clear. Barry brought that out. I brought it out. It does not avoid probate, but it does give clear instructions for assets that go through the court process and reduces family confusion. Now, a trust, on the other hand, is a legal entity that lets you place your assets under the management of a trustee so that they can be protected, managed, and distributed according to your instructions. Get this, during your life and after your death. A will only is there for you when you what? When you pass away. Okay? A trust can protect you during lifetime too. It helps avoid probate, right? I'm going to say in most cases. Keeps your affairs private. We talked about that already. And provides ongoing control and protection for beneficiaries. So it's really good for us to understand the difference between the two. In my opinion, potentially Barry's, it's good to have both to get the full array protection for your state. Okay. And so let's go ahead and talk about some of the differences of the Trustee Friend platform versus maybe some of the other experiences you've had working with other providers, potentially even, certain law firms. So, Trustee Friend number one, we offer free initial consultations to get an understanding of your goals, concern, and family dynamics. Other providers charge high consultation fees without taking this time to understand your full goals or family situation. Maybe you get a half hour only with them. Okay. We have prompt turnaround with the initial draft documents typically being delivered within 24 hours. So we meet with you, we do our assessment, you choose a plan, we take the questionnaire that we do. 24 hours later, we have an initial draft. With these other folks, slow turnaround times with drafts taking weeks, potentially even months. I spoke with an agent the other day, and she was working with a different provider. She says, Ray, my client still hasn't gotten their plan, and it's been 7 months. 7 months. That is just absolutely ridiculous. On the third, bullet point there, we have a collaborative team approach with dedicated estate planners and partnering attorneys, over 80 attorneys, 9 different languages. We're able to work in all 50 states. On the other side, oftentimes you get limited support, often handled by a single professional. Maybe it's just a sole practitioner, right? With no collaborative team support. Going back to Trustee Friend, we have personalized planning tailored to your wishes, assets, and unique family structure. Okay. Over there on the other side, some of you may experience being nickel and dime for every little modification, name change, things like that. That doesn't make it for a pleasant experience. And then lastly, you receive support from start to finish by actual people, not AI or anything like that when you work with Trustee Friend. On the other side, oftentimes you get little to no guidance after documents are delivered. Sometimes they'll just email you the documents after it's completed and say, you review them and go through them. And it's like you're kind of left on your own to figure out next steps. And we really want you to understand, the level of support that we give. Again, very friendly environment, always working with a real human being, always being guided to make sure that you accomplish what you're here to accomplish, right? And that's what, to protect your families, protect your state. Just a little bit on our process so you get an understanding of what to expect. So number one, we do the intake, right? And here's where you sit with a person, typically over Zoom, and we gather all the necessary information and submit it so we can start your plan, okay? Once we gather that information, as I mentioned, the next thing is we draft the documents, typically generated very quickly, usually within 24 hours, right? So that we can move on to the next process, which is the review. Depending on the plan that you pick, our team will sit and review your draft with you for completeness, providing guidance to ensure that everything reflects your goals and wishes. And then lastly, we ship it, right? Typically after, the first 3 steps are done, we can get that plan into your hand within a week to a week and a half. We put it in a nice Trustee Friend binder That's important. It's not just being emailed to you. And we're going to do the extra little bit of work of marking every page so that when are going to get it notarized, sign here, sign here, date here. We want you to be able to make sure that it's done correctly the first time. So that's a little bit about our process. I want to go through the actual plans that we have available. The first three are what we call standard planning. So these are our revocable living trust plans. And I want to take you through these. We're going to be very transparent about the pricing and what these plans consist of. So the first one that we have is called Guided by Friend. Okay, so the way that this one works, it's typically for very simple estates, and we're going to give you some case studies here in a second to see if that fits your circumstances or somebody that you know. But it's for very simple estates, and what we'll do is we'll have a dedicated account manager that's going to guide you through the intake questionnaire, right? That's going to be used to create the documentation, right? So you're going to have some help on the front end. Uh, Deed preparation is included. This plan is our most affordable. It starts at $850. Okay. Our next plan is called Guided by Planner. Typically, a planner is a paralegal, oftentimes. And this is for the folks that need a little extra help. You're going to have guidance through that intake process, but you're also going to have guidance on the back end. These planners are going to lead you through a comprehensive review to ensure that your estate planning documents are appropriate, clearly understood, and properly executed. Deed preparation is included in this one as well at no extra cost. These two plans do not automatically come with our mobile notary signing service. We do have that available for an additional $150. They'll go anywhere in the United States. I like to say typically our notary service is about half the cost of anywhere else you go. There's about 15 to 20 signatures per plan. A typical notary will charge $15 per signature, and then of course there's the travel time. If you do the math, we're about half the cost, but you can go wherever you like. Some banks will notarize your documentation for free. If that's the case, hey, great, go do that, right? Our last standard plan is guided by attorney. Okay. We have bar licensed attorneys, as I mentioned, over 89 different languages that will guide you through the intake process, provide legal insight, provide guidance. They lead a comprehensive document review to assure, again, that all your state documents are appropriate, clearly understood, and properly executed. It does have the deed preparation included, and it also includes a mobile notary service. This is our white glove, all the bells and whistles plan, and this one is 1850. I also want to make notation that all these plans can be put on a monthly payment plan option for extra affordability. Typically, it could be as little as the cost of dinner for two, right? To your monthly payment to protect your family, which we think is very, very reasonable. Lastly, we have advanced planning available. We know it's not a one size fits all world. So for the clients that have sophisticated planning needs, they need something extra outside of what is standard. We have bar licensed attorneys that will lead the engagement from start to finish. Usually you're going to get your free consultation. You will work with that attorney, which will deliver a fully tailored estate plan strategy. Again, you have that attorney-client relationship. Deed preparation is included in this one. Typically, these start at $2,999. Okay. These can also be put on a monthly payment plan option. I'm going to go a little bit deeper into what advanced planning is in a minute, but I just wanted to give you an idea of some true to life cases that we have, and it'll help you identify, well, maybe this plan is good for me, or maybe it's good for, a neighbor or a loved one. So let's go through Jake and Melissa, right? So they're a married couple who recently purchased their first home. They have no children, no business interest. They hold a simple joint bank account. Their wishes are straightforward, and they have some extra time to review the documents on their own. They chose the guided by friend plan. Okay. There in the middle with Sarah, it's a little bit different, right? So let's take a look at her situation. She's a 45-year-old single mother with a minor child. She owns her own home. She has a 401k, life insurance, wants to name guardians for her child while customizing distributions as she has a nephew that she wishes to provide for. She has no extra time and feels overwhelmed by legal matters. She needs that extra help. right? In the beginning and also in the end. She chose the guided by planner. Again, as I mentioned, is typically going to be a paralegal. And then over there on the far right, you've got Robert and Janine. They're parents of two minor children. Janine is a sole practitioner, and together they co-own two rental properties. They're seeking guidance on how their real estate should be handled within their estate plan and want legal guidance to ensure everything is structured correctly. They want that extra help. They chose the guided by attorney, again, that will lead the engagement from start to finish. So just gives you an idea of why we've structured our plans, three different options to fit basically three different situations with unique circumstances out there that maybe you have or folks that you know have. Next, again, I told you I wanted to touch a little bit more on when standard planning isn't enough. I want to focus a little bit of time on the advanced plans that we have available. We have dozens of them, but I do want to talk a little bit about you know, where this can fit into maybe even some of your situations. Maybe you didn't think there was a plan available for those situations. So let's go through these one by one. So, number one, an advanced plan could be a great option for somebody that has vulnerable beneficiaries. Okay. Think about somebody with special needs in your family. Okay. I told you all I have three kids. I also have four grandkids, and they're all brothers and sisters, same parents. Two of the four special needs. My 9-year-old grandson is nonverbal autistic. His sister, born right after him, is also on the spectrum. According to the Center for Autism and Related Disorders, 1 out of 36 children born in the United States is born on that spectrum. Okay. And typically, a standard plan may not have enough provisions built in it to provide for our loved ones that need, future care considerations. Okay, I always see a child with autism eventually becomes what? An adult with autism, oftentimes outliving their parents. So we have to think about that, right? Other situations can be somebody that needs a little bit enhanced financial protection. Maybe we have some loved ones that have some substance abuse issues, gambling issues, or they're just minors, right? A minor can't receive a life insurance uh, death benefit. So we want to put some extra provisions in these plans to designate, some more instructions and understanding of how distribution should work for these ones. You don't want to drop $1 million into an 18-year-old's lap, right? If something should happen to you, so they don't go out and spend it on who knows what, right? Have a bit more instruction in that. Number two, clients with long-term care considerations, Medicaid planning. Many folks are going to need to avail themselves to that Medicaid planning. And we want to be able to take into consideration the spend down that may be required, right? Basically, to take advantage of any governmental benefit, you typically have to be very poor, or they want you to spend every single penny that you set aside for maybe emergency on your care before can be accepted into a program. These special plans could potentially help you avert that spend down and still be able to receive Medicaid or another governmental benefit. Number three, clients with blended or complex family dynamics. There are a lot of people out there, including myself, right, who are in our second marriage, and maybe we have assets and children from previous relationships. Sometimes people want to keep, those assets separated. That's fine. It's perfectly okay. Or in the event that there's a situation when it comes down to guardianship, who did the children go to or with, right? The step parent, former parent, who knows, right? But we want to make sure that we plan ahead in the event something happens in these unique family structures. Next is succession planning for your businesses. We touched on that earlier. But again, making sure it's structured correctly for tax purposes, for continuation purposes is extremely important, right? And I'm building a business. It's not easy, and I'm sure it's the same with a lot of you. You want to make sure that that business is protected in the best way possible. And then clients with international considerations, uh, assets out of the United States, family members outside of the United States. Oftentimes, this can be used for folks who are working on their citizenship, as I like to say. Maybe they don't have all the documentation necessary right, to be here in the United States, but they've been here some time, acquired some assets, maybe a home, maybe even a business. Definitely, a lot of folks have family. We want to be able to provide the protection that we can in the event something should happen, i.e., deportation. Potentially, they leave guardianship instructions as to what happens to the home, business, or other assets. All right, so that is our presentation for this evening. Um, as I mentioned, I wanted to open it up for you to be able to ask questions to Barry. Again, he's extremely knowledgeable. He's with Trustee Friend for a reason. He was a professor or is a professor, right? Law professor. And, I don't want you to be shy about it. If you are, put your questions in the
Yeah,
chat or take yourself off mute, raise your hand. We want to make sure that your questions are answered. I'm going to take down my contact information. Hopefully, if you needed it, you got it. I can always put it back up. But I'm going to turn the floor over to Barry. I'm going to look into the chat and
yeah.
see if there's anything here. Oh, we got one.
There's one question already. So, Helen, so the question, if you can't read it, is property that has a mortgage able to move into a revocable trust? Absolutely, yes. Yes, yes, yes. The so again, the basic revocable trust, the person creating the trust, you're still in charge while you're alive. You're the trustee while you're alive. The mortgage is a contract that you signed with the bank that you will pay the mortgage off. So nothing changes when you transfer the house into the trust. The mortgage still needs to be paid off. And if you don't pay the mortgage company can still put a lien. The other interesting things that some people are hesitant about, anyone who in their primary residence who has homestead exemption, all the states kind of have homestead exemption for your primary residence. It's kind of a discount on the property taxes, but it's also if there's a major lawsuit against you personally, they could take everything but not the house. That transfers as well. So when you have an existing property, again, that's what we create a deed for. So after the trust is created, the deed transfers out of your name into the trust. So again, when you pass away, the trust still owns the house and all the other assets, and it avoids probate. The next question that most people ask about the houses is you don't have to amend your document every time you buy or sell your house. So today, Diana is calling up the real estate agent. Hey, real estate agent, I, Diana, own a house. I want to sell it, so sell it. And I, Diana, want to buy a new house. If we do the Dunham-Nelson Family Trust, same phone call, Diana's like, hey, real estate agent, I'm the trustee of my trust that owns a house. I want to sell it. And I want my trust to buy my new luxury house because I'm building my empire and I'm moving up in the world. So the idea is she didn't have to come back to us and change anything. And actually, she doesn't need a new deed because at closing, the trust that you created is now going to be the owner from day one. So we only have to transfer today. She creates the trust. We have to go through all the issues with getting the current house in your name out of your name and into the trust. Okay. The other last thing, just and I know I'm talking to a lot of insurance agents. So there's no problem with the mortgage. There's no problem with homestead. There's no problem with the homeowner's insurance policy either, but insurance companies are sneaky, and Diana better call her homeowner's insurance and say, I want my trust as part of the policy as well, because we've seen actual cases where Diana did everything right, but didn't put the trust as someone who could make a claim on the homeowner's insurance policy. And I'm not saying which insurance companies, I don't want to offend anyone, but that's kind of something. And in our written instructions, we clearly say that when we deliver the documents. In our meeting, we'll probably tell you that, but I'm just saying as kind of insight for you. But I hope that answered your question. The next question is how much is the fee? I'm not sure, Helen, what fee you're talking about, and I'll defer to my boss Ray to answer whatever your question is about the fee.
Sure. So I'm thinking, Helen, and of course you can correct us if we're wrong. What are the costs of our revocable trust? We have an 850 plan, a 1250 plan, and an 1850 plan, dependent on the amount of assistance that you need, and of course your circumstances. So if that's not what you were referring to, feel free to, add a little bit more info, detail into your questioning regarding this fee. But the cost of the trust is 850, 1250, 1850 for the standard plans. And then, of course, we have
And,
advanced
and,
planning.
and all of those plans include one free deed. That's part of
Mm-hmm.
the cost. We
Yes.
assume most of our clients have one house. If you're lucky enough to have a second home, a vacation home, and maybe a third home and stuff like that, we have an additional charge for each additional deed. I think it's $150 if I recall.
$150, yes. And e-recording is available too, so you don't have to go down to the county recorder's office for $50 per deed.
But we,
Okay.
we, we assume every client comes to us and they own a house, they own jewelry and artwork, and if you, as Ray was saying, you start coming to us and you own three jet airplanes, or you own, the horses in the backyard that you use for the polo matches. Now your assets are a little more complicated, and we may have to do an advance plan. And on that, guns and firearms are the other asset that we at least have to give you some advice and options about, do you want to specifically plan for the guns separately in your estate planning strategy or not? And there's no right or wrong answer. It's just question. You just have to kind of understand what some of the issues might be.
Awesome. Thank you.
And I just want to emphasize, I'm sorry. Ray mentioned the business. That is an asset in your name that if you did not properly plan for what happens when you die, the business can go through probate. So if you don't treat the business properly, all right, you put the house in the trust and you put your jewelry in the trust and everything's in the trust that passes, but your business, especially if it's a service business that owns a building and all that, that's going through probate, which means a year down the line, when the probate hearing is over, and after you spent a lot of money on attorneys, have employees been paid? Have clients been contacted? So at the end of the year, if you didn't plan properly for the business, uh, what are you giving to the kids? You're not giving them an ongoing business, you're giving them junk equipment that hasn't been cared for. So that's really, especially small business owners, it's like this is what you're building, this is what you're spending your time and effort. And the succession planning is, well, does it go to all three kids equally? Oh, only the daughter is going to take it? Is there a way we can just give money to the other kids so that the one who wants to run the business can run it? And for someone like, Diana, it's kind of, hey, that we're going to help. Is there another insurance policy specifically for the purpose of equalizing wealth that you can now do? Because again, if you're referring your clients to us, you've already established the relationship. They need estate inviting us to be part of your team that supports your client. And it's kind of we're all here to help each other. We're focused on the estate planning documents and everything, but the idea is we're invited to be part of the team, and we're not here in competition with anyone. So I just
Awesome.
want to emphasize that.
All right. Thank you so much. Does anybody else? Oh, Helen, does that answer your questions?
And I have just a quick question. You asked me about the fee. I'm talking about I have a trust, revocable trust already. So I would like to have move my two other property which has mortgage on it. Just move the two property to my current trust. So this is how much cost.
So I'm thinking we need, and Barry, you feel free to chime in, but I'm thinking we need to do an amendment right, on your current trust to add in these assets. If I'm not mistaken, is that correct, Barry?
Maybe or maybe not. I mean, we if we didn't do the document, we have to unfortunately spend some time and effort reviewing your documents because they were prepared by another attorney. And we could give you advice. We're not looking to, but we really don't give advice for free. I don't know what your current trust says and everything like that. We could set up a meeting if you'd like, and have a discussion one on one without it being in the public domain here. But you
Sure.
know, so we gladly will review people, give a second opinion or something, if you have an existing plan and help you decide if it's still accomplishes what you want and everything. But if we do if you hire us from beginning to do the plan in the future, anytime you have questions, you come to us. We have everything in our computer and we could go forward. Here, you kind of went to another attorney, and I just can't answer the question just on a Zoom call. If I hope that doesn't offend you. I'm just trying to be honest with you, Helen.
Yeah.
Okay?
And we do have a range for uh, amending plans outside of our network. Typically, it starts at about 250, could go up. But again, that only applies to, plans that we didn't, create. If you get a plan from trustee friend and you need to make an amendment like that in the future, we'll never charge you. What Barry's talking about is if somebody else, another attorney, another organization prepares your plan, we will review it for free, but if it needs an amendment, there is a cost for that amendment. Typically, it starts at 250, could go up. I hope that answers your question.
Okay, all right. So I can set a meeting with you for free.
Yeah, we'll look at your plan, complimentary and again, provide you with some guidance uh based upon the information in there and what you want to accomplish. So no problem with that.
Okay.
Absolutely. Okay.
So what is the那个范美就是test me the trustee friend that one I can just sign up and then have an appointment on there.
Helen, did you were invited by Diana, right?
No, Fan Mei.
There you
Fan
go. Then Frank
Okay.
May can handle you
Yeah.
setting up the referral appointment for you. It's very easy. She can handle that, and
okay,
you can work with her to pick a date and time that'll be appropriate for you to meet with Barry or somebody else.
okay, all right.
Okay. Awesome. Okay. Oh, she got the link. Okay, thank you, Frank May.
Oh, okay.
Beautiful. All right. Anybody else have any questions? We're good. Okay. Thank you so much for joining us, allowing us to present, answering your questions. Thank you, Barry, for joining us, Diana for hosting this, and everybody that attended.
Thank you guys so much for coming and giving us this very important information. I appreciate you all being here. And I just always, when I'm done with these calls, I'm like, where was Ray and Barry when I was a kid?
Right.
So just make sure you guys are taking heed to the information. Have your make sure your family is protected. That's really the driving force behind what we're doing, making sure that families are protected. So allow us to be part of your team to make sure that you're properly covered in all areas, and accomplishing the goals that you want to accomplish for your family. So it's about leaving a legacy, and that's just what we're trying to do. So thank you guys again. Have an amazing evening, and I'll see you guys soon.
All right. Thank you, everybody. All right. Bye bye.